Judgment has been reserved until Friday in the Western Cape High Court in the matter between lobby group Afriforum and Parliament. Afriforum has made an urgent application aiming to suspend the adoption of the Constitutional Review Committee report, paving way for the amendment of Section 25 of the Constitution.
The lobby group wants to interdict the report from being debated for possible adoption by the National Assembly on Tuesday, pending their substantive court application aiming to challenge the committee's process.
A legal row as Afriforum digs in its heels to halt the committee's process. At the center of their argument is that 176,000 written submissions were ignored by the committee. As a result, they believe the outcome of the process will be misleading and skewed.
Where we are dealing with a simple factual issue, and that is, could you exclude could you delegate, firstly, your committee powers to a service provider? And secondly, is the exclusion, whether by the service provider or by the committee, rational? Those are factual issues which do not require an answer to a difficult political question. So our submission is on both those scores. The matter is properly before this court.
While Parliament's legal counsel acknowledges that written submissions were overwhelmingly against an amendment to the Constitution, he argues oral and public submissions were overwhelmingly in favor of the amendment. He says the public consultation process was not about numbers, but rather substantive and meaningful participation.
Two parties are concerned explicitly about the so-called exclusion. It's the Freedom Front Plus and the DA. No doubt, when the matter is debated before the National Assembly, the Freedom Front Plus and the DA will raise the question as to the exclusion, the so-called exclusion of submissions. That simply shows that there is entirely no irreparable harm. We have been straitjacketed, pushed around and forced to come to court to defend a case in circumstances where it is completely premature.
Afriforum has also taken issue that written submissions were processed by an external service provider. They believe that Parliament is outsourcing its responsibility. But Parliament's legal counsel says this is not abnormal, as some legislation are drafted by external experts. He says the test is that any decision must be approved by the relevant parliamentary structure.
Then there's Part B, which is a very comprehensive review process. And that comprehensive judicial review process will carry on. And the suggestion was made by both parties today that perhaps parties should get together and agree on a timetable and put that to court.
Even in their arguments, there's no challenge on the appointment. They are saying they're going to do it later. That there was consensus between us and them that the appointment of the service provider is not challenged today.
Judgment will be delivered on Friday at 10 a.m. in the morning. Ulelani Philip, SABC News, Cape Town.